To every cow belongs her calf, therefore to every book belongs its copy. If you're confused, that's arguably one of the earliest judgments in a copyright dispute issued in Ireland way back in 6th century AD. Basically, it means that if you had the original book, you got the copy, just like a calf belongs to its mother cow. This ruling led to a big battle with, get this, 3,000 casualties. But let's fast forward to now. In today's world, where generative AI, short videos, and a constant flood of content rules the scene, it's nearly impossible to keep track of who's copying whose work. As one of our guests in the episode puts it, the phenomena is rampant online. And if by some luck you find out, what can you really do? Is the onus on you or the media platform hosting the content? A lot has been brewing when it comes to copyright infringement cases in India. From Anil Kapoor getting an order to protect his style of saying jhakaas, to Amitabh Bachchan seeking protection for his voice and personality rights. But most recently, a lawsuit filed by the storytelling page Humans of Bombay against People of India brought the conversation of copyright infringement to the forefront. But what is the case really about? And will it impact the life of digital creators who are creating content for Instagram and YouTube? What options do these creators have when their content is blatantly copied? In today's episode, I will unpack all of this for you with our guests, Shefali Bhatt, who is an internet culture reporter at Economic Times.
The person who is actually stealing from you is also stealing that opportunity, that engagement, that acknowledgement, and that recognition from you, which could have possibly led you to be noticed by a certain brand that would be eager to collaborate with you.
Content creator Varun Duggirala.
The problem oftentimes is that you only start correcting yourself once you get called out. And more often than not, this is something which you should do much before that happens.
And legal expert Anupriya Dhonchak.
Tricky thing with social media is that it has blurred the boundary between freedom of speech and expression and commercialization. So you could be expressing yourself and making profit at the same time.
It is Tuesday, 10th October. I'm your host, Apurva Mittal, and you're listening to Copy versus Copyright. Whose content is it anyway? Only on The Morning Brief.
I think in one word, it is rampant.
That's Shefali Bhatt. She's the internet culture reporter at Economic Times. Shefali wrote an interesting piece about the opportunity and monetary loss small creators face when large verified accounts steal from them.
If I were to sort of give you tiers, right? So there'll be video clips taken from someone without credit. There'd be video clips taken with a caption saying, DM me for credit. Then there'll be some clips where there'd be like a caption, then ... and right underneath there will be the credit buried. Sometimes it would not even be tagged, like the person whose clip they're using, it won't even be tagged. So I've seen that on some meme pages where they would be curating some stuff and there would be no mention of where they've taken the content from. And on top of it, they actually add their own watermark on that video, claiming that it's actually now their video. It happens with voice as an audio, because audio is also chief sort of ingredient of content these days, especially on Instagram. And it happens with text so blatantly that you don't even know where to start.
Shefali, any cases that stuck with you?
So this was a particular case where a creator who's comedian and now has gotten into gaming, her entire audio for a particular clip that she had posted was taken by a much more popular verified creator / actor. And a lot of people pointed this out to said actor, at which point they started just closing off comments on that particular piece and apparently blocked this person for raising this in DMs very politely. This is just one case that came out, But this happens on a daily basis. I remember just a few days ago, I noticed that there was one meme account that had put up this clip from a very old interview, which had this watermark of their own and no mention of the actual interviewer who was interviewing this artist whose clip they had recently lifted. And since then, I've seen many more such cases where you notice that this is a curation account and you just keep wondering, okay, who is the actual creator who created this? While you may not be able to directly point out loss of money and opportunity, but the person who is actually stealing from you is also stealing that opportunity, that engagement, that acknowledgement, and that recognition from you, which could have possibly led you to be noticed by a certain brand that would be eager to collaborate with you.
How are creators trying to protect themselves and inhibit this practice where an account is lifting off their content and using it like its own? What remedies are they resorting to?
I do think that majority of the people whose content is stolen brazenly on the internet do not have the time, the bandwidth, or the legal resources or the wherewithal to actually take these matters up legally. Forget legally, they don't even have the bandwidth to take this up with Instagram on DM. I think in most of these cases, people just let it be. It's not something that they're happy about, but they just feel that it's just too much to get into when there's cycle that they're on where they have to produce a certain number of reels every day or every 3 days. And they have to look at their own analytics. There's just too much to keep track of already with their day-to-day work for them to also then keep track of who is plagiarizing from them. The ones who have teams are able to kind of do that. So, which is why you don't probably see that with a lot of big creators, because it's also very obvious that people would know whose content it is.
Shefali is right. For small and up-and-coming content creators, the sheer time and resources it requires to challenge a copyright violation could seem daunting or even pointless. Our next guest is content creator Varun Duggirala, who has hosted several successful podcasts. He suggests that the simplest approach can sometimes be the most effective, which is speaking out against it.
What ends up happening a lot of times is someone will spot something really interesting. They'll say, okay, let me now make it mine. And the standing joke on Twitter for the longest time was everybody was tweeting out what Naval Ravikant tweeted. So because everybody wanted to sound like Naval Ravikant, I think that went on for a while till people start calling them out. The problem oftentimes is that you only start correcting yourself once you get called out. And more often than not, this is something which you should do much before that happens. So for instance, my show is called Take a Pause, and a pause is written as a pause. We did apply for a trademark for that, right? Because that's a term which we wanted to kind of own and use. And we went through the regular channels and worked with the legal advisor to get that in there. In cases where, I'll give an example of a format. I hosted a show called Think Fast. Me and Suchita Salvan, who's the CEO and co-founder of LBB, we hosted it. We had a very clear frame of reference of a show in the US which we were emulating. And it's a show called Pivot, hosted by Karas Fisher and Scott Galloway. Our format was exactly the same. So when we started the show, we openly spoke about the fact that it's our homage to a show which we've really enjoyed. And that often also kind of helps any discussions you might want to have in that sense of the word.
Varun, you spoke about how you have given credit. But what about protecting your own work or cases where you see a lift-off?
So there's a lot of resharing that happens. I'll pick a few cases. There's something that's been said on the podcast. Someone's taken a piece of that from my own Instagram account or my podcast Instagram account, and they end up cropping out any form of branding we have and sharing it on theirs. Our general DM to them is, we're very happy for you to share it. Just make sure you tag us in it. We also have branding in frame for that reason. So our mics have the show logo smacked onto it primarily for that reason. Someone takes it, shares it. We're still kind of showing source in that sense.
Varun, so your branding sticks out. But what about engagement, traffic, and the monetary component of all of it? If someone is getting engagement based on your content, that is essentially a loss for you, right? How does the creator ecosystem really deal with that?
I've spoken to a few creators, and this is a few cases which I've come across. Someone's taken that content, made it their own, and also getting clients, and that becomes a lot more tricky. I've seen a lot of call-outs happen on that front, both physical as well as like general life coaching and business coaching spaces as well, where frameworks get moved around, content gets appropriated, because eventually everyone's trying to get that customer. And that's why I feel for creators using your content to sell a certain service, this becomes a very important and crucial piece to look at. Otherwise, you end up losing much larger revenue. In another case, what ends up happening, if it's the regular kind of content which someone's taking, I feel the lens is slightly lesser. You just have to keep evolving and creating. I don't think you can do much in the other case. But in a case where it's directly affecting your income, I feel the problem is far larger.
Where do you see platforms hosting these creators coming into all of this? Are they doing enough to protect creators' IP? And, we can specifically talk about Instagram and YouTube here, and maybe Spotify, since I'm guessing you have experience working with them as well.
Yeah. I think YouTube's a great example. If you're using, let's say, a music track, or if you're using a piece of some other content, it often you do get that nudge in your YouTube studio. So when you seem to have used something that's copyrighted, do you have the necessary rights to use it, etc.? You end up getting taken off if you don't go through that process. So YouTube actually has, I'd say, the most robust platform in that sense. If you look at it from an Instagram standpoint, you can't promote an Instagram reel if you've used copyrighted music on it. And Spotify as well, it's an interesting case where, for instance, there was a podcast for a while where someone was taking content from a very popular live streamer and putting it up as the podcast. And I only realized much later that wasn't the creator doing it. That was someone just taking his content, putting it out there. But because the creator didn't put up a complaint, the platform is not liable to take it off. So it also becomes about the creator figuring out, okay, one second, someone's taking my content, they're putting it on another platform and they're getting some form of scale and distribution from it, or possibly monetizing it. And they'll have to call it out with the platform.
But let's come back to the genesis of this episode. The Humans of Bombay lawsuit against People of India. Our next guest, Anupriya, is a lawyer who focuses on the right to monetize one's image in the digital age. She will break it down for us.
So I think Humans of Bombay has a pretty good case, because if you look at the order, the other website, People of India, was copying photographs from Humans of Bombay. What was interesting was that everyone on social media assumed that Humans of Bombay was getting sued for just lifting the idea. They claimed, obviously, more broadly. So they seemed to claim for first specific infringement of particular stories, texts, and photographs. And then they also claimed for infringement of the website layout, which gets a bit more murky because formats can be protected, but it's a question of how detailed the format is to be worthy of protection.
Yeah.
And what gained a lot of traction, especially on social media with the Humans of New York creators tweet, was the model of storytelling itself and whether that is protected. So a lot of people assumed that Humans of Bombay has sued People of India only based on that model of storytelling. And I think this is the weakest claim, because that model core idea of storytelling is too abstract and unprotectable.
So, Anupriya, I have because I've only gone through the screenshots that Humans of Bombay put out on Twitter, X actually. But isn't POI, why can't they go to the same people and tell their stories and, get pictures from them and post it on their Instagram account? That's one of the things Humans of Bombay has mentioned, right, in their lawsuit, that there was a direct copy paste. But is it a copy paste, or is it like copying the idea that I want to go to that person and tell their story and get their picture?
So I think it wasn't as abstract as just a model of storytelling. Their claim was that exact stories were copied, stories, narratives that they had edited by themselves, that they had put substantial research into, photographs that they had taken themselves. And if those photographs are independently taken, there is no element of copying involved. If I'm lifting someone else's photograph off the internet, then that implicates certain rights. And it's interesting that you mention, what if that person themselves wants to share their photograph on multiple platforms or their story on multiple platforms? But the editor has already put in enough effort in editorializing that content. So you have to look at the originality threshold and the protectability threshold in the law. The larger point is that that person might want to share their story with other platforms, but then the photographer has a copyright in the image that they're capturing. And then Humans of Bombay potentially has copyright in that image if through their employment contract, that employee has assigned the copyright ownership to Humans of Bombay. And a section of the Copyright Act basically deals with this. So
Okay.
in any lawsuit, basically, you will have to show both existence of copyright, which is proof of originality, and then you would also have to prove ownership, that you have
Yeah.
copyright over the protected parts of the story. Now, it's also
Right.
again important to realize that certain life stories of people are not again protected by themselves because their life stories are in the public domain, right? So people are free to comment on it, people are free to draw inspiration from it. So that proving of ownership over the protected parts is really important, and employment contracts will also feature in this.
Anupriya, moving a little forward to replicated content, what happens when a bunch of aggregator accounts are sourcing content from different creators and posting it or uploading it without crediting the original creator for it? Now, does the copyright or protection kick in?
So if someone's taking a reel and then creating an aggregator page and getting likes, the tricky thing with social media is that it has blurred the boundary between freedom of speech and expression and commercialization. So you could be expressing yourself and making profit at the same time. But if it's a case of blatant copying, you haven't added any original element, and the work in itself is protected. It has crossed that threshold of originality, and passing it off as your content and making money out of it, then there are laws to protect that. Where it gets trickier is when you are just free riding on someone else's content. Someone else has created something. You're not harming them. You're not taking away from their engagement, because a lot of times what happens is when content gets shared via fan communities, when they're not adding anything to the content but just resharing that content, it actually adds to the celebrity value of the creator. So creators should also be wary of using the law too strongly to clamp down on sharing and resharing of content.
Anupriya, but if a creator does intend to pursue shutdown of these copycat accounts, how difficult is it really to implement?
Yeah, so doing this against multiple users or accounts is likely to be a game of whack-a-mole, and there's a lot to address. I think pursuing this particular case was strategic for Humans of Bombay itself as well. What courts do in some IP cases is that they pass orders to block websites when you think that they are pirating content or not voluntarily complying with the court's orders. And especially when courts face difficulty in identifying who the infringing parties or the defendants are. These are called John Doe orders generally, and the Indian version of it is Ashok Kumar orders. But these orders, again, they suffer from the same problem that I was talking about, that they can be really broad and they can completely block off access to a website because courts don't have enough time or obvious difficulty in identifying who the defendants are. And so the misuse of John Doe orders in India has also been criticized quite a lot now.
Are there any examples or any major cases or rulings on copyright on social media content that you can share either from India or internationally?
So internationally, there have been a lot of cases. Instagram has gotten sued multiple times. Getty Images has gotten sued multiple times. In India, I don't think there's any case on social media copying in particular. There was the case of T-Series versus MySpace, where T-Series had filed a copyright infringement suit against MySpace, which was a social networking website. And T-Series claimed that MySpace was allowing its users to upload and share copyrighted songs without proper licenses. And the court held that it was liable for copyright infringement, and it directed the platform to implement certain measures to prevent unauthorized sharing of copyrighted content. And then now there is the Anil Kapoor order, which is the path we don't want to take. Because if you lump together these vastly different users, AI being used to create pornographic videos of someone versus someone just using a celebrity's likeness to parody, something or to make fun of something or to comment on something, then they're not the similar kinds of users. One is a use that leads to actual harm, and the other is a use that actually doesn't lead to any harm. So I think you should think about it in terms of harm and not whether it's benefiting another party. Because a lot of parties seek to gain from cultural goods, from public goods, information, expression, which is in the public domain. And that doesn't necessarily harm anyone. If someone is making profit out of something, that's not necessarily harmful. And the law should focus on whether there is actual economic or dignitary harm caused, and then tailor remedies accordingly.
Other social media platforms that allow digital creators to host this content liable in case of copyright infringement, or is it just upon the account holder to protect his IP?
So platforms usually have terms of use and terms of conditions that everyone is signing on to. So only when they're alerted that this content is infringing are they under an obligation to take it down. But at the same time, these are, like I said, a lot of these boundaries and a lot of these cases of whether something is infringing or not are not clear-cut cases. So this also can lead to, having a proactive filtering obligation or a proactive takedown obligation on platforms can also lead to private regulation of content, where platforms are now making decisions that courts are supposed to make between what is infringing content and what is not, because a lot of these cases are not easy and they have fuzzy boundaries and indeterminate boundaries that require balancing different interests.
Platforms pulled off protecting music, but now as they are pulled between engagement and protection of content, the task is definitely not a simple one. But social media platforms are using safeguards to discourage copying content. For example, on Instagram Reels, if you try to promote content that includes copyrighted music, GIFs, interactive stickers, or camera filters from a third party, you won't be able to. But copying words and passing off as one's own is still something that's upon creators to identify and call out. And as generative AI becomes more common in content creation, figuring out the originality quotient may become more challenging. The discussion about copying and copyright will keep changing as our legal system deals with various cases and interprets the law. For now, keeping this conversation alive seems to be at least one way to raise awareness and potentially discourage copying. This episode was brought to you by sound editor Indranil Bhattacharya. Our producer is Sarohini Jain. Our executive producers are Anupriya Nair, Anirban Chaudhary, and Arijit Burman. Thank you for listening. If you liked this episode, do share it on your social media network. A new episode of The Morning Brief drops every Tuesday, Thursday, and Friday. Don't miss it. It streams on Amazon Prime Music, JioSaavn, Spotify, Apple, and Google Podcasts. And of course, ET's own audio platform, ET Play. Have a great week ahead. All clips used in the episode belong to their respective owners. Credits are mentioned in the description.